All right. Thank you, everyone.
Good morning, Your Honor. Happy Friday.
Happy Friday. Glad to see everybody made it in. Okay, first up, I have Mr. Tuttles here on Hicks.
Yes, Your Honor.
Is there a co-defendant on your case?
Is not on this case. This is he has two cases not in front of you today, but this is the second degree murder case, correct?
Correct.
Are we just doing the one?
Yeah.
So no, there's no co-defendant on that case.
Okay.
And excuse my coach, Your Honor, I'm at my office. The heat is off in this building, and they're working right outside my office, making noise.
All right. No problem.
Is Ms. Bonoma?
Yes.
Case number 2305-569601. People of the state of Michigan versus Cortez Hicks. Defendant is charged in count 1, homicide, murder, second degree, count 2, operating while intoxicated, causing death, count 3, reckless driving, causing death, count 4, operating while intoxicated, causing serious injury, count 5, operating while intoxicated, causing serious injury, count 6, operating while intoxicated, causing serious injury, count 7, reckless driving, causing serious impairment of a body function, count 8, reckless driving, causing serious impairment of a body function, count 9, reckless driving causing serious impairment of a body function. Defendant has a felony commission with a motor vehicle for adult advisory.
Appearances for the record, please.
Good morning, Your Honor. Sarah Bonoma on behalf of the people, P841189.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles, on behalf of my client, that's Mr. Cortez Hicks, who is physically not present in your courtroom. Mr. Hicks is at the Wayne County Jail. He should be appearing via Zoom. Or my camera does not, my computer does not show Mr. Hicks present at the Wayne County Jail. I see Wayne County Jail, but I don't see Mr. Hicks.
Do you want to waive his presence or you want to wait on him?
I waive his presence for this particular probable cause conference.
Court of waiving the defendant's presence. What's your pleasure?
No, we do have discovery, Your Honor. However, it hasn't been able to be printed out, but we want to set it for in-court preliminary examination.
Continue to plead of not guilty. We'll set this matter for preliminary examination. How is March 21st at 11:30?
Uh, 11:30, yes.
What are those other cases?
His PCC is March 20th. Yeah, I think it's the second.
What's the charge in that?
Homicide.
Okay, so you want to handle the PCC for the other case as well, Mr. Tuttles?
Yes, we can do that.
Okay, but that one we do have a co-defendant on.
Yes. I'm not sure that the co-defendant is in custody.
Your Honor, if I may, the co-defendant is in custody and his PCC date is on the 21st.
Okay, so Mr. Tuttles, let's move your PCC on that case back to the 21st with the co-defendant.
Okay, okay,
That'll be at 8:30. That way we don't have to contact the attorney.
So this exam is still going?
Yes. Oh. 21st. So we have it anyway, the 21st. 11:30. Okay, so we'll have your client on that day anyway for the exam. We'll do the PCC as well on that day, the other case.
okay.
Why don't we continue?
Okay, one other question. What is the date that you had for Mr. Hicks as it relates to the PCC on the first degree?
It was on the 20th, but I'm moving it to the 21st, the same day as the exam.
Okay,
Your Honor, is that PCC going to be set at 8:30 and then the exam will be at 11:30?
So do you want to just do them both at 11:30?
we can do that.
Okay, so we'll set the PCC at 11:30 as well.
Okay. Okay, that's good. Does that conclude this matter?
Yes, sir. Bond continue. Thank you.
Okay.
Thank you, Your Honor.
good. Madam Prosecutor, you want to send me the discovery, or you can start getting the discovery on the first degree to me?
Yes, I can do that.
Okay, thank you.
Thank you.
All right, everybody have a great weekend.
Thank you, you too. Wayne County Jail, who is this? Yeah, I lost. Anyway, Mr. Bradford, good morning.
Good morning, Judge King. I'm here for Ms. Bowser.
Okay,
Calling case number 2305-560301 for the state of Michigan versus Jasmine Bowser. Defendants charged in count 1, malicious destruction of building 1,000 or more but less than 20,000. Count 2, domestic violence.
appearances for the record, please.
Good morning, Your Honor. Shelley Dunn for the people, P number 60249.
Good morning, Judge, student and staff. Cody Bradford, P85944 with NDS Detroit on behalf of Ms. Bowser, who is present via Zoom.
Ms. Bowser, tell me your name for the record.
Good morning, Jasmine Bowser.
It's your pleasure, Mr. Bradford.
Yes, Judge. First, I apologize for missing yesterday. I put it on the wrong date, so I understand that's my fault. So my apologies for hindering the court schedule. At any rate, we would like to set this for an in-person preliminary exam, please. I will be on vacation from the 17th through the 29th, so I could do next week, or it would have to be after I get back after the 29th, Judge.
Will you be available on the 17th?
On the 17th, I have something already at 9, and then I leave after that for my flight. I could do the 15th, Wednesday at like 10 or 11 if you have it available.
I don't.
Okay. Or the 16th.
I have 9 o'clock available on the 15th.
Say again, what time?
9 o'clock.
9 o'clock? Okay. I do have another exam at 8:30, but we can schedule it for 9 a.m. It might be a few minutes late.
March 15th at 9 o'clock. We continue.
Thank you, Judge. Thank you, APA Green. Ms. Bowser, I will give you a call.
Thank you.
Thank you.
Mr. Quickard.
Good morning, Judge. How are you?
Good, sir. How are you?
I am awesome. Thank you. I am here on Mr. Marcus Inman. It's not on your docket today.
And if I may, Judge, in previewing next week's cases, I spoke with the complainant on the case, People versus Marcus Inman, and this complainant had called the prosecutor's office numerous times, telling a number of people that she did not want to go forward with this case and she wouldn't be appearing for court. I spoke with her myself and confirmed that, yes, that is exactly how she felt. So I gave Mr. Woodyard a call to say that this case would not be going next Friday, March 17th. And, you know, if we could dismiss this ahead of time, I think that would be efficient.
Okay, the court will dismiss this matter without prejudice. What time was it scheduled for on the 17th? Oh, we didn't call it? Oh, I'm sorry. Let's call it. Thank you.
Calling case number 2305-567101. People of the state of Michigan versus Marcus Inman. Defendant is charged in count 1, assault with intent to rape by harm less than murder. Count 2, child abuse 4th degree. Count 3, domestic violence.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
And Judge King, good morning, sir. Michael Woodyard is my name, P64612. I'm a staff attorney with Neighborhood Defender Service Detroit. We represent Mr. Inman, and he's on the call. Mr. Inman, say good morning and say your name, sir.
Good morning. This is Mike Inman.
Judge, it was indicated off the record by Ms. Drain that the people will not be moving forward and that the complaining witness refuses to testify at this time. And the people are to dismiss this matter now. Is that right, Ms. Drain?
Yes, Your Honor, that is correct. I would also indicate for the record that I would not even be able to proceed without her testimony.
And Mr. Woodard, I'm sure you have no objection to that.
Your Honor, Mr. Inman has no objection to proceeding in this fashion.
The court will dismiss this matter without prejudice.
Thank you, Judge.
Thank you so much, Judge. It was set for noon on the 17th, Judge.
Thank you very much.
Judge, if I may very briefly, Mr. Inman, did you post a cash bond, sir?
No, I bail's bondsman.
Okay. The necessary paperwork, Judge, will be forthcoming, I trust, or?
Yes.
Okay, Mr. Inman, you'll get some stuff in the mail, sir, and give me a call.
All right. Thank you.
Thank you, Judge. Thank you, Mr. Rain.
Thank you.
Grant Miller, are you still there? Mr. Miller going once, Mr. Miller going twice. Mr. Noakes, good morning.
Good morning, Your Honor. I'm here for the PCC of Mr. Quentin Oates, who's in the Wayne County Jail.
Is this Mr. Oates here in Wayne County? What's your name, sir? Unmute yourself. Tell me your name. What's your name, sir? What's your name?
Who, me?
Wayne County. Yes, sir. What's your name?
Alexander.
Dante Alexander.
Uh-huh.
Okay, we're just waiting on your attorney, sir.
All right.
Can you get the deputy? Can you get the deputy for me?
No.
Can't get the deputy for me, why not? Why not, sir?
Huh?
I asked you to get the deputy for me. Call the deputy.
The deputy.
Yes, Judge.
Good morning, sir. Do you have a Dejan Oates for me?
Good morning. Mr. Oates is at the old jail. I'll let them know you're ready for him.
Okay, thank you. Who else do you have there besides this defendant?
I have no one at this jail besides Mr. Alexander. Jail, they also have a Cortez Hicks as well.
Okay. We did Cortez Hicks already. His next court date is March 21st at 11:30.
March 21st, 11:30.
Yes, sir.
Thank you, Judge.
Your Honor, if I could proceed by waiving Mr. Oates' appearance, we've already met and he's interested in having an exam.
Okay, sure, no problem. Let me call the case.
Calling case number 2305-550401, people of the state of Michigan versus Dejan Oates. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, weapons, felony, firearm.
Appearances for the record, please.
Good morning, and may it please this honorable court, APA Jonathan Hicks appearing on behalf of the people, P 85288.
May it please this honorable court, William Noakes, P 42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Dejan Quentin Oates. Your Honor, with your permission, I'd waive his appearance.
For the waive the defendant's presence, what's your pleasure?
We're asking for an exam date.
How is March 17th at 10:45?
That would be fine, Your Honor.
All right, March 17th.
Judge,
at 10.
I'm going to be out of the country at that time. The following week, though, I should be able to make work. I know you do.
I'm sorry. I didn't realize this was a homicide. I'm sorry. That's not going to work anyway. When are you leaving town, Mr. Hicks?
I leave tonight and I get back on Saturday, the 18th. So the week of the 20th, if I could do the 21st or the 23rd, those days would work.
What time is best for you on the 23rd, Mr. Noakes?
Your Honor, any time should be good. I have a trial that begins on the 20th, but I expect it to be over by the 22nd. So anytime on the 23rd would be fine.
And I do have a motion hearing scheduled for 2 p.m. that day. I could probably move that if I need to, but if we get do it in the morning, that'd be perfect for me.
Let's say 11:30, just in case Mr. Noakes goes over a little bit.
Thank you, Your Honor. 11:30 on the 23rd.
Yes, sir.
And Judge, I do have one other matter for the record. I did send in a protective order to the courts with Mr. Noakes's permission. I signed that document. I haven't received an executed copy back from the court yet. I'm wondering if you are in receipt.
I signed it this morning.
Oh, you signed it this morning? Okay, thank you, Judge.
And Mr. Hitch, just to be sure, I'd like to make sure I have all the discovery before you leave town.
I will make sure I get it to you today.
Okay, thank you. Thank you, Your Honor.
Thank you. Have a good day. Enjoy your weekend.
You too. Bye-bye.
Like my attorneys.
I ordered out Thomas case. He's also kind of killed over there.
Yeah, what now?
I ordered out, I ordered him for Zoom, Thomas Pace. Mr. Mongrace here.
Okay.
Yeah, he's in the kind of killed.
Oh, okay. Officer Byrd.
Yes. Good morning.
Yes, sir, how can I help you?
I'm here on Nicole Kimball.
You may not be in the right place. What's the charge?
It was have a stop sign and I believe a no license.
Yeah, this is the criminal exam courtroom.
Okay. It said, yeah, it said on my notice it said Jones. Is this the right room?
No, this is Judge King.
Oh, okay. You know the courtroom for Jones?
I believe it's 435, right? 360-435-0000.
Okay, 435. Got it. Thank you.
All right.
Bye.
Mr. Montgrady, good morning.
Morning, Your Honor.
You're here on pace.
Yes.
Case number 2305-566301, before the state of Michigan versus Thomas Oates. Defendant is charged there, count 1 and 2, assault with a dangerous weapon, count 3, domestic violence. Defendant has a habitual offender for defense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Jane for the people, P number 60249.
And good morning, Neighborhood Defender Service by Kate DeMott Grady, P 83667, on behalf of Mr. Thomas Pace, who is out of custody, and I ask to waive his presence for the purpose of this hearing.
Court will waive the defendant's presence. What's your pleasure?
Judge, if I may, I did call Ms. DeMott Grady and ask her if she would be willing to agree to adjourn the exam date, which is currently scheduled for next Tuesday, March 14th. As this is really your homicide day, I was asking if she would mind adjourning this. And Your Honor, I actually did ask in anticipation that the Marcus Inman case was going to be dismissed. I did ask her if March 17th, this next Friday at 12 o'clock would be good for her, and she said it was. So we do have a date we agree upon if that is all right with the court.
That's a good date for you, Mr. Montgrady?
Yes, Your Honor, it is.
All right, so the court will adjourn the preliminary examination scheduled for the 14th to March 17th at 12 o'clock. Donald, we continue.
Thank you.
Thank you, Judge, and thank you, Ms. Grady.
You're welcome. Stay safe, everyone.
You too.
Good job, Ms. Green.
Thank you.
So, Alexander case, it's supposed to be doing the civil commitment.
Morning, Mr. Howard. Mr. Howard, good morning.
Good morning, Your Honor.
You ready on Alexander?
I am.
Okay. Yes.
Calling case number 2205-904001. People of the state of Michigan versus Dante Alexander. Defendant is charged in count 1, criminal sexual conduct, first degree.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Morning, Your Honor. John J. Holler on behalf of Mr. Dante Alexander. My bar number is 43344. Mr. Alexander is joining us from the Wayne County Jail by Zoom.
And Mr. Alexander, tell us your name for the record, sir.
Dante Alexander.
All right. Okay, so Ms. Ripley, have we made any headway?
Your Honor, we're working on this. Yes, I have been in contact with, I first started out reaching to the Center for Forensic Psychiatry. They gave me some referrals of people to reach out to. I did reach back out to the Wayne County Jail. We are trying to work with them to see if we can get the neighborhood, what are they called? The community mental health services that Mr. Alexander has out in the community. We're hoping to get them. I asked if they would be able to evaluate him by any way at the jail. We're trying to work to see if we can get him evaluated again by either a psychiatrist from the jail who they have or the neighborhood services. So we're just working on that to see if they'll be able to do that right now.
Say get him evaluated.
Yeah, for a petition. So he has to be, they have to have that note within 72 hours that they evaluated him, and they would either refer him for a petition or write the petition to send to probate court, or they would see that he doesn't meet the criteria. So we're just trying to get the community mental health, we're trying to see if they will come and evaluate him.
Are we beyond the statutory time frame yet, the 15 months?
No, Your Honor, the 15 months is not up until next April.
I see. They don't believe that they can get him competent within the statutory time frame. All right. Mr. Hollow?
Yes, Judge. Mr. Alexander is developmentally disabled, and he's been developmentally disabled permanently since he was essentially born. And Dr. Baker concluded that he was not going to be restored to competency because he's never had competency. Competency is not something that he can achieve. I don't know exactly what the problem is over there at the jail, but it sounds to me like there are people who are being paid to do a job that decide they're not going to do it. And within the Department of Human Health and Human Services, and it's none of our faults that the people who are responsible for doing the jobs they're being paid to do can't do or won't do the job they're being paid to do, which is evaluate Mr. Alexander within 72 hours of a petition being filed, so they can professionally represent to the court that within a very short time is required by the statute that they observed him and observed him to be incompetent. and what they did observe, didn't observe, and they can't do that. And now Miss Ripley and her colleagues are in the awkward situation of trying to cast hither and yon to drag somebody into the jail to do the job that other people who are being paid to do the job won't or can't do. I don't see any end to this, and I think that my client ought to be stepped down and go live with his guardian, Miss Vanilla Underwood. In the meantime, I don't, with all due respect to Miss Ripley and her colleagues, I don't see this really moving forward, to be honest with you. This, and frankly, something ought to be done by the prosecutor staff through the Department of Human Services to hold people accountable for not doing the job they're supposed to be doing.
Judge, if I may, I don't know that that's entirely factually accurate that they're not doing their job. The Wayne County Jail did have someone evaluate him. They do have other people who I'm asking that they can reach out to also do it. It's not that they're not doing their job. They are aware of his status. They are aware of his intellectual disability, and I think that they are working with us, and we're trying to, I guess, exhaust any and all options that we can to figure out how we can figure out our next case.
Would an order this court speed things along or not?
I'm not sure at this point, Your Honor. I am just waiting to hear back from the community mental health. And they've been responsive so far. So I don't think at this point, if there did come a time where one would be needed within a week, I would reach out to the court for one.
The fact that people in the jail are aware of my client's situation is meaningless. The issue is whether he's been properly evaluated and a petition has been filed with the probate court, which the law requires. To be aware of a situation and do nothing about it, or be unable to do anything about it, avails us not. He should be released on bond, on a tether. And then they can do all the evaluation and petitioning to their heart's delight, if they ever get it done.
How then, if he's released and he's out on bond, how do we secure his presence to be evaluated?
We can secure his presence because his guardian is responsible. His guardian is Vanilla Underwood, and he's lived with her ever since his mother passed away, which is for many years. She has appeared before this court. She doesn't use Zoom by herself at all. She has to have a neighbor help her, so she's not on Zoom. She's not watching. I really doubt seriously that she's watching either on YouTube or anything today, because she just can't figure out that she's elderly and she can't figure out she doesn't figure it out well. So after these hearings, I call her and
what's the relationship of the complaining witness to the defendant in this case?
The complaining witness, I believe, is a cousin, if that's what you asked me.
Yes.
And they live in the city of Detroit, but not in the same neighborhood.
She doesn't live with the guardian, does she?
No.
Was the defendant receiving any treatment prior to this incident?
He wasn't receiving any treatment, as you and I would call treatment. He had a job that I think through Goodwill or Salvation Army Services, where he could go every day and keep himself occupied doing tasks that were understandable to him that he could do under supervision.
Yeah, I think he was receiving
got paid a little stipend for doing it. So that was kind of, it's what we call work therapy, to keep a man occupied.
I'm going to release him on bond, because I think all of us would agree that jail is not the proper place for him. If I'm to release him on bond, I would prefer that he be placed on house arrest and have no contact with any child under the age of 16, although this didn't involve a child, did it?
No, it did. It involved a 7-year-old, Your Honor.
It involved a 7-year-old? Oh, okay. No child, no contact with any child under the age of 16. So I'm inclined to do that, but I would also like for the guardian to be made aware of any dates that she needs to bring the defendant for evaluation.
Okay, that will be no problem. The guardian has the assistance of her daughters and other extended family that can be all the assistance that's needed to make sure that my client is transported to where he needs to be.
Okay, so if we have any issues whatsoever of him missing an appointment or anything, then I'm going to revoke that bond and put him back in to make sure that he doesn't miss any more.
Understood.
Right now, we're going to release him on house arrest. No contact with any child under the age of 16, and must attend all scheduled evaluation appointments.
Understood.
And as soon as I know of any appointments to schedule, I will let Mr. Holler know so he can make sure that Mr. Alexander can be there.
Who wants that? Who wants the honor of preparing that order for me?
I'll be glad to prepare the order, and I'll send it to Ms. Ripley to review, and we can get it to you.
Thank you very much. I appreciate it.
Okay.
Thank you, Judge. Oh, should we get it? Do we need another date?
Yeah, we should probably put it out for, I want to say 2 weeks or a month.
I could do either the 31st or the 14th of April. I'm supposed to be in trial the other days.
I can't do the 14th. I'm sorry, just a second here.
Let's do the 31st.
Okay, the 31st is good.
All right, thank you, guys.
Thank you, Judge.
So that honor, she said that in this with chapter.
It's house arrest, so I'll do a personal bond. I'll do whatever the cash bond was, I'll make a personal bond, house arrest. Contact with the child. Personal bond. Mr. Alexander, you're all set, sir. You're gonna be going home.
When?
Sometime today, most likely.
Today?
Yes, sir. But I want you to be on your best behavior, okay?
Yes.
Keep your hands to yourself.
And I'll be good.
All right, I appreciate that. I look forward to it, okay?
Thank you.
All right.
See, you the best judge I ever had.
Thank you. I appreciate that.
Thank you. So I'm going home today?
Yes, sir.
Yes.
Or as soon as they get a tether for you, okay?
All right.
All right. Johnny L. Young, Sister Sandy.
Today. So Judge King,
Yes, sir.
so can I go anywhere, like with my auntie?
No,
Like,
sir. We're gonna make sure that you stay home until you get your doctor's appointments and so forth, okay? That's the condition of you getting to go home. You're not gonna be in jail, but you're gonna be at home all the time,
oh,
okay?
but like, can I go like outside? Or I gotta stay in the house?
Yeah, we're gonna have you stay in the house for right now.
I could dig it.
Okay.
So when I go back to court,
When do you go back to court? You go back to court on March 31st.
so do I walk in?
No, you don't have to walk in. You can appear on Zoom like you're doing now.
Like at home?
Yes, but you'll be at home. So you'll have some of your family help you out with getting on Zoom, okay?
Okay, cause my auntie got it on her phone.
Right. Okay. So whatever phone or tablet or computer you use will be fine.
All right.
You can let the deputy know you're all set.
I'm all set. Come on.
All right, sir, we're all set. Have a great weekend. That's an order.
You too. Thank you, Judge.
All right. Happened to Ms. Drain.
She got the wrong witness.
Okay. Are you ready, Ms. Drake?
Yes, Judge.
All right. Calling case 2355444, people of the state of Michigan versus Johnny Lee Young. Defendant is charged in count 1 larceny from the person, count 2 aggravated domestic violence. Appearances for the record.
Good morning, Your Honor. Shelley Drake to the people, key number 60249.
Good morning, Your Honor. Simon Keel on behalf of the defendant, Johnny Young, who is present to my left. Mr. Young, please state your name for the record.
There's the date and time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
I do have a couple of preliminary matters, Your Honor. I did file 3 motions in this matter. The most important motion, Your Honor, is defendant's motion to suppress and request for an evidentiary hearing. One piece.
I have no interest in conducting the evidentiary hearing at the preliminary exam stage.
Well, my concern is this. One piece of evidence that was provided to me is an alleged confession from my client. I don't know what the prosecutor's intention is, at least for purposes of today, if we're going to play that exam. But I would be concerned about that exam. About the prosecution claim that particular video recording and alleged confession to the court. One of the position that the defense has taken is that my client has some intellectual disability, and I've already reached out to an investigator through the Neighborhood Defender Services, but I have to get records. So I basically need to get additional records to give over to this investigator and get her signed up on the case so that she could do a forensic exam of him, basically, and determine what his IQ was. So I have an issue with that entire confession. Now, if the people are proceeding without that particular evidence, then I would just move on to my other 2 issues.
And if I may, Judge, I just have one witness that we the complainant, and that's all I'm going to be presenting. I'm not going to be presenting any confession.
Okay, so then my second issue is with regard to, in the discovery, the request for a warrant has a statement in there that says that a detective had a conversation and took a statement from the witness. I never got a copy of that. The only thing I got was the police report, but I don't see anything from this particular detective, Carmelo Walker. So I don't know if that exists or if it doesn't exist. That was part of my motion to compel. Well, it's my request for missing discovery in addition to other discovery that was supposed to be made available to me yesterday, but it wasn't. But I guess my only concern is that I don't know what this.
I'm sorry, is this what you're speaking right here?
Okay, so this I have.
Yes.
This is what Walker wrote.
This is all that I have. I don't get anything else.
You have nothing from Carmelo Walker that you can see in?
This is.
Is she pregnant? All right. I guess I don't think.
Ready to proceed now?
Yeah.
All right, call your witness.
Thank you, Your Honor. At this time, the people will call Maggie Sanders.
Good morning, ma'am. Please step forward, give your name and the spelling of your name to the young lady seated over here. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat in this witness box right up here. And with this, placing your left speak directly into this mic.
Yeah.
All right, you may begin when you're ready.
Thank you. Okay, October the 9th.
No, ma'am. Wait on questions.
Oh, okay. Please state your name for the record one more time. Maggie Sanders. All right, Ms. Sanders, I'm gonna be asking you some questions today. If you don't understand something or if you want me to repeat it, please let me know, all right?
Yeah.
Okay, thank you. All right, Ms. Sanders, I want to bring your attention back to the date of October 19th of last year, 2022. Do you remember that date?
Yes.
All right, where were you on that date?
Well, leaving my father's house, going to the store for him and myself.
Okay, you said leaving your father's home?
Mm-hmm.
Okay.
Apartment, I'm sorry.
Apartment?
Yeah.
And you were gonna go to the store?
Yeah, for
Okay.
him and myself.
Okay, so did you leave your father's apartment?
Yeah.
What happened when you left?
When I shut the door, Jay, he called himself Jay, but his name is Johnny.
Okay,
He was-
and what is Johnny's last name?
For the
Yeah.
record, the defendant did not say a name, or the witness did not say a name.
Said Jay,
That's
she
what-
said John.
Correct.
That was an objection.
All right, you said Johnny Young?
Yes.
Okay, now, do you see Johnny Young in the courtroom here today?
Yes.
For identification purposes, could you indicate where he is and what he's wearing today?
A brown jogging set sitting over there.
Thank you. Your Honor, please have this record reflect that this witness has identified the defendant, Johnny Young.
So noted.
Thank you. All right, you indicated you saw Johnny Young when you left your father's apartment, is that right?
Exactly.
Okay, what happened after that?
I asked him, what is he doing here? He was supposed to be there.
Okay,
He was fussing and cussing me out like no tomorrow. And I was like, whoa, wait a minute. But you're not going to do that in front of my dear partner, knowing that he have a heart attack. And I know you don't care. You just kept going on and on.
okay.
So I left. I'm sorry.
Already stopped for a minute. How do you know Johnny Young?
I met him doing, leaving a laundromat.
Okay, so did you have a dating relationship with him?
A little bit, yeah.
Okay, all right. Okay, so are you and Mr. Young still in front of your father's apartment?
Yes.
Okay, what happens after that?
He and I study arguing. I'm study telling him he shouldn't be arguing with me about nothing. He didn't listen, he never did. Anyway, we left, going down the stairs, study arguing. Leaving the apartment, study arguing. Going to the grocery store, study arguing.
Okay, so you did actually go to the grocery store, is that
Yes.
right? How far is the grocery store from your father's apartment?
Give and take about 3 blocks.
Okay, so you just walked there?
Mm-hmm.
What did Mr. Young do?
He walked with me, arguing with me, cussing.
What was this argument about?
You tell me, and I know too. You couldn't tell me. I don't know. I think he just wanted to argue that day, but why? I was too nice to this man, claiming to do this to me. My finger is broke.
We're gonna get to that. So did you get to the grocery store?
Yes, but I never went in.
Okay, let me ask you, where is this grocery store located?
On Lafayette, in Shane,
Lafayette and Shane,
Yeah.
what's the name of the grocery store?
Family Fair.
Okay, and is that in the city of Detroit, the county of Wayne?
Yeah.
Okay, thank you. All right, so what happened when you got to the grocery store?
Study arguing with him.
Okay, so both of you are there?
Mm-hmm.
Where are you specifically?
In front of the grocery store.
Okay, so still arguing.
Yes.
What happens after that?
He snatched my bag and took 8. I'm sorry, go ahead.
He snatched your bag.
Correct.
Okay, was this a purse or some sort of bag?
It was just a regular bag. You know how you go to the corner store, gas station, grocery store, whichever one, and they give you a fancy bag, just something, yeah.
Did you have a purse with you and a bag or just a bag?
I had the bag with my purse in there, my phone in there, and my keys in there.
Okay, so everything was in the bag?
Yeah.
Okay, so you said he snatched the bag from you?
Yeah.
What happened when he snatched the bag from you?
He went in my purse, stole $86. I watched this man do this, and I hollered and screamed. So he's stealing back. He said he fussing, cussing at me, and said, no, I ain't taking nothing. I ain't stealing nothing. But later on, 2 minutes after that, he showed me money doing this. I said, so you stole my money?
Did you see him take the money out of your purse?
Yeah, I watched it.
But then he said he didn't take it.
Exactly.
Okay. So he went in the bag and went in your purse in the bag, or did he take the purse out of the bag?
He took the purse out the bag, got the money out, Brian threw it at money, and he left.
Came right back though.
Okay, did you go in the store?
No,
Okay. What did you do next?
I called my daughter and told her that he's tripping and I don't understand why he's being stupid.
Why did you call your daughter?
Because I want her to witness how he acted.
Did you want your daughter to come up there, or did you just want her to hear on the phone?
I just want her to hear.
Okay. So you said that all of your stuff was in the bag.
Mm-hmm.
So after he took the bag and took the purse out, did he give you the bag back?
Yeah, he threw my purse and what little papers I had inside my purse on the ground. So I ended up picking up my purse and papers before they flew away.
Okay.
And he left like he wasn't nothing. So that's fine.
Well, was anything else in the bag?
My phone and my keys.
Okay.
All that broke.
It broke?
Mm-hmm.
Was your phone broke?
Yes, I had to pay $110 for a phone that I already had.
Okay. All right. Were you able to still use the phone at that time?
I barely could see, because you know, once you break that glass, you barely could see or hear what's going on.
Okay. Did you get a new phone?
Yeah.
Okay, and you paid $110?
Yeah.
All right, he said he then left.
Mm-hmm.
Are you standing in the parking lot?
Yeah. No, we're right in front of the grocery store.
Okay, all right. So, after the incident happens with the purse, then he leaves, and then he comes back.
Exactly.
And you never went in the grocery store?
No.
Okay.
So he arguing with me, cussing me out.
So what happened when he came back, if anything?
I'm here ready to go inside, because I still have to get the items my father and I need.
Okay.
But before I could do that, I said, no, I'm not gonna go home and walk away. So I walked away to Jefferson.
Okay.
And I'm looking, as we speak, in front of me, he comes behind me, snatched my baby in, my finger got caught in it. My finger broke.
Okay. We're gonna take this step by step. You decide not to even go in the grocery store.
Correct.
And you're walking away.
Yes.
You said he comes behind you and snatches the bag again?
Yes.
Does the bag have all your stuff in it still?
Yes.
Okay. So how did this happen with your finger?
It must have got caught inside the bag some way, somehow. Next thing I know, when he comes from behind me, I can't see him. I'm looking in front of me. When he snatched the bag, my finger fell.
Okay. Did your finger hurt right away?
Yes.
Did you say something?
Yeah.
What did you want?
My finger is broken.
So your finger was broken from that?
Yeah.
Okay.
Because it had to be my finger and holding it in some way, somehow, and I think that's why it got broke. Stuck in it when he snatched it in the bag, it broke.
Okay. Did you receive medical attention for that?
Yeah.
How did you receive medical attention?
I went to urgent care.
Okay. And did they treat it or give you anything?
They gave me some medicine for the pain, and they fixed it up. I don't know the name of it, but I know it's steel. Put it in my finger, thought it would come back right, but it never did.
Did that? Okay. So did your finger go back to normal?
No.
Okay. So what is the condition of your finger today?
I can't hold anything.
Can you hold up your hand just to show us? Okay.
Yeah.
Okay, and which finger is it?
This one. It don't go down like this one, see?
So this is the ring finger on your right hand, is that correct?
Yes.
Okay, and you can't bend it all the way, can you bend it, can you bend all your fingers?
It don't stay up straight, see? It don't stay up straight, it don't lay, it's just there.
Okay, and are you, other than it not being able to bend, are you in any pain still?
Yeah.
Are you having any issues? What are those issues?
I'm in pain every day because of my finger. I can't lift anything, I can't roll anything. It won't bend, it won't stay straight. I'm in pain from it. When I take my bath, it just hurts. You know, I barely could do what I used to do. But he got 10 minutes, I got 9.
Okay, so let me just ask you a couple of questions. So after he grabbed the bag again, and your finger broke, What happened after that, if anything?
I called my daughter again, and I said, I'm about to go there. Urgent care. She said, why, man? I said, I think my finger broke. She said, oh, no. And she came right away.
Did you go to urgent care at that point?
Yes, I went there.
What did you see Mr. John Young do again?
He just left, like it wasn't nothing.
Did he still have the bag?
No, he threw the bag at her.
Okay. All right, so you were able to get those things back?
Yeah.
Did you get everything back? Did you
Except for my money.
the money? Okay.
How much money was it? $86.
Mm-hmm.
Okay. All right. I have no further questions.
Cross exam?
Ms. Maggie, Ms. Sanders, you testified that on October 19th, you did not enter the grocery store.
I did after the fact. I had to go get my car.
Did you enter the grocery store at any point with Mr. Young?
No.
Never stepped one foot in the grocery store?
On that day?
On that day. Let me start again. We're talking about October 19th, okay?
Mm-hmm, right.
So when you left your father's house, with Mr. Young.
Mm-hmm.
In fact, Mr. Young brought you to your father's house that day.
Mm-hmm.
So you invited him to your dad's house, correct?
No, I didn't.
He brought you.
He dropped me
Stop,
off.
hold on, I'm asking a question. Yes or no, okay? Mr. Young was at your father's house on October 19th, correct?
Yeah.
You asked him to take you to your father's house, correct?
Sure.
Okay. Then Mr. Young was there at your father's house with you, correct?
No.
Okay, but you were both inside the apartment building, correct? Yes or no?
No.
Okay, at some point, Mr. Young is at where you are at your father's house. Is that
Because
true?
he just
Yes
popped
or
up.
no? Just yes or no?
He just popped up.
And he was there and you were there, correct?
And
And he knows where your father lives, right?
Mm-hmm.
Because you told him that information, right?
Yeah.
Yeah, right?
That don't mean you pop up.
Yes, that was just a yes or no question. I didn't ask you anything else. Just listen to the question. You've asked him to take your father to the dentist in the past, correct?
Mm-hmm.
You've asked yes or no?
Yeah.
You've asked him to take your father to the doctors, right?
Yeah.
You've asked him to take your dad to have his haircut.
Okay.
Yes or no?
Yeah.
Okay, so he's run all these errands for your father and his cat because you wanted that, correct?
Mm-hmm.
So on this particular day, on October 19th, he was at your father's house, yes or no?
Yeah.
Okay, the two of you left from your father's house, correct, together?
Yeah.
And you walked together to this grocery store, correct?
Yeah.
And your testimony today is you and Mr. Young together did not enter that grocery store.
Not together.
Okay,
no.
that's it. That's all I'm asking. So, Mayor Prosecutor asked you how much how much money was removed from you, correct?
Mm-hmm.
Your testimony to this court is that Mr. Young took $86 from you.
Mm-hmm.
That's a very specific number. You're very clear about that
You
number?
have to answer yes or no.
Yes.
You're very clear about that number. It's not a different number. It's $86.
Mm-hmm.
Not a penny
Yes
more.
or no?
Yes. Not a penny more.
Not to my knowledge.
And not a penny less.
No.
Okay. Is it true? You're not a medical doctor, are you?
No.
Okay, so you have no training in healthcare treatment or treating yourself for a broken bone, correct?
Yeah.
And your testimony today is that your finger was broken, correct?
Mm-hmm.
And that's
You
what.
have to answer
I'm
yes or
sorry.
no.
Yeah.
Okay. Okay, so your testimony is that you had a broken finger?
Yeah.
And your testimony is that you told the 2 police officers that day that your finger was broken?
Yeah.
And you were offered medical assistance from both police officers, correct? Let me rephrase.
Yeah.
When you were in contact with police on October 19th, they offered medical services to you.
Yeah.
You said no.
Yeah.
You did not want any medical treatment, correct?
No.
Hold on. Even though you said your bone was broken, you said you did not want medical treatment. Is that true?
Yeah.
Okay. You made a decision to not have immediate medical attention for a broken bone, correct? Yes or no?
Yeah.
Okay. Now, while we're still talking about October 19th, when you were in front of the police, you remember the 2 police officers, right? It was a male officer and it was a female officer, correct? Okay. They questioned you about Mr. Young, correct?
Yeah.
And while you were standing there, you pulled your telephone out, correct?
Yeah.
And in pulling your telephone out, you started to you actually used your right hand, didn't you?
I can remember that.
You don't, you have no memory. So everything we've talked about so far, you remembered, right?
Mm-hmm.
But you don't remember which hand you would have used to look up information for the police?
No, because
okay, yes or no? These are yes or no question. Okay. All right. So you don't remember using your hand to look up information on your phone?
No.
Okay. And you don't remember using your telephone to get John Young's phone number?
Yeah, that I do.
Okay. And you do remember now, all of a sudden, you're holding onto your phone and looking up Mr. Young's phone number for the police, right?
Yeah.
And then you used your hand to give that to find that information on Mr. Young's phone, right?
Yeah.
And then you gave that information to the police,
Yeah.
correct? Okay. But you can't remember which hand you were using today?
No, but
These are just yes or no?
No.
Okay. Do you what day did you or urgent care?
When I was 13, I think it was the 20. The next day, if I can put your hand.
That's all I asked you. So your testimony today with Madam Prosecutor and myself, we talked about October 19th, right?
Mm-hmm.
We haven't even talked about October 20th, right?
Mm-hmm.
You just brought up October 20th.
Have to answer yes or no.
Yes.
Okay. So you didn't get your broken you're alleging your finger is broken. You didn't get that treated until the entire day passed, and the next day you got treatment. Yes or no? Okay, so you didn't get treatment on October 20th.
No.
Which day? I asked you this, and you said October 20th. So now you're changing your answer.
Okay.
Yes or no? Are you changing your answer?
No.
Okay. So you were treated for what you're calling a broken finger on October 29th.
No.
Sorry, October 20th.
No.
Okay, so you are changing your answer then, is that correct?
I'm sorry. Yeah.
Okay, what day did you get treatment for your alleged broken finger?
19.
The same day?
Mhm.
Okay.
Say
And,
yes?
Yes.
and where did you go?
Urgent care on Jefferson.
Okay, now let me ask you this. You had been in a relationship with Mr. Young, correct?
Mhm.
And
Answer
Yes.
Stop saying, because it's very difficult for us to decipher what that means when she's put typing it out, okay? So you have to answer yes or no.
Okay, I'm sorry.
now, okay, so you had, do you recall an incident about sometime before October 19th falling at a gas station? Yes or no?
No.
You have never gone for, you don't have any memory of falling at a gas station at all?
No.
You have no memory of talking to Mr. Young about a fall at a gas station?
No.
Okay, and had you received any medical treatment prior to October 19th?
No.
You had never been to the doctors in the past, let's say 60 days before October 19th?
No.
Okay. On October 19th, the finger that you alleged was broken, were you able to move that finger?
No.
Nothing further.
Can you redirect?
So you were asked about whether, or not you remember which hand you used to access your phone to give information to police officers, is that right?
Yes.
And did you remember which hand?
Yes.
Which hand?
The right one, but not the third one. My finger, my first finger.
Okay, so you used your right hand, but
Yeah.
just the one finger?
Just roll up and down, yeah.
And why did you use just your one finger?
Because I ain't paying no attention to my broke finger until I started getting pain, and I happened to look at it.
Okay.
Sorry, Your Honor, you have a repeat, I could not hear it again.
I didn't pay attention to my broke finger until I was in pain, and I happened to look at it.
Okay. Also, you indicated you did not request medical attention from police officers when they had asked you for it, correct?
Correct.
Okay, and why did you not?
I wasn't in pain then. I didn't notice until later, after the fact.
When were you first in pain?
About 3 hours later.
Okay. How did you know that your finger was broken?
Because I tried to move it and I couldn't, and I was in so much pain. That's when I went to urgent care, and that's when we said that.
Okay, all right, very good. And when Johnny Young took the bag from you, did he make any statements to you at all?
No. Could you repeat the question? I'm sorry.
When he grabbed the bag from you,
Yeah.
did he make any statements to you at all?
No.
Before or after?
Just cussing me out.
Just cussing you out.
Mm-hmm.
All right. Okay, thank you. I have no further questions.
Mm-hmm. Yes.
So, ma'am, you say that the ring finger on your right hand is the finger that was broken. That's the finger that was injured, right?
Yeah.
Did that cause you not to be able to move any of your other fingers in that hand? Did you use the other fingers?
My baby pinky hurt because I got too close to that finger.
Okay.
Here, lately I
But
can
you
move.
can use your other fingers?
Yeah. I can use it, but it still hurt my baby pinky.
All right. Any questions based on my question?
Okay.
Thank you, ma'am. You may step. Any other witnesses for the people?
I have no further witnesses, Your Honor.
Any witnesses for the defendants?
Oh, done.
Your Honor, at this time, though, based on the complainant's testimony, I would move to amend the information to include an additional count of malicious destruction of personal property, 0 to 200 for the phone that was broken and needed to be replaced. The complainant stated she had to replace her phone, and it costed $110. So this would be a misdemeanor.
That's what they do, that's what they do. Oh, my
Do you have any objections to the line?
I just want to make a comment on, with regard to the domestic, there's an aggravated assault charge, so we would look for, a dismissal of the aggravated domestic violence, based on the testimony that she gave. For one, on cross-examination, she couldn't even indicate which finger, was broken, yet she was using the phone, but when prosecution came up, she was quick to say yes.
That's not exactly true. She said during the right hand cross exam that it was her right hand ring finger that was broken. And then she showed it to the court.
Okay, so I would further then state to this court, that this one's. It is the complaining witness that is drawing this conclusion that this finger is broken. There is no other additional evidence that was presented by the prosecution to support an actual broken finger, other than the witness's statement. So based on the fact that there's nothing to show an aggravated domestic assault, we would respectfully request the court dismiss this charge.
You do acknowledge that a witness sworn testimony is in fact evidence.
Sure, and the court can give it the way that it wants to.
Yes, Your Honor, I would first say this is a misdemeanor, not a felony charge. And in addition, the witness clearly stated that she showed the court her finger, she can't even make it straight now. She was in a lot of pain, and she did seek medical attention. So I'm asking for a binding word with the additional count of MVP 0 to 2.
As the prosecutor indicated, they need not show evidence of a misdemeanor at the preliminary examination. The domestic violence aggravated is in fact a misdemeanor, and people don't have to present proofs of that charge at the preliminary exam. As it relates to the larceny from the person, which is pretty much contested here, the court is satisfied that people that their burden is probable cause as it relates to the charges contained in the complaint warrant. Court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be March 24th, 2023 at 9:00 a.m.
Does the court able to tell me if the arraignment is on Zoom or?
The arraignment is on.
Okay.
I need the statute for the MVP.
Your Honor, the statute is MCL 750.377A1D.
All right, thank you.
Thank you.
Narrow here. Calling case 2355537, people of the state of Michigan versus Gennaro Bondenario here. Defendant is charged in count 1 assault with intention to great bodily harm listed murder by strangulation. Count 2 domestic violence. Defendant has a habitual report.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Daniel Woodson, P 68870, on behalf of Mr. Garrett, who is standing behind me.
Tell me your name, sir.
Gennaro here.
And there's the time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is Ashley Tate. She was notified of today's hearing. She is not present, and I cannot proceed without her testimony.
Your Honor, based on that, with respect to the request of this matter to dismiss without prejudice, citing double person and 5 counts in 28.
So order, the court will dismiss this matter without prejudice. I need a dismissal order. No, this is.
We're Frank. Oh, okay.
Morning, Your Honor.
Good morning, sir. How are you doing?
I'm blessed. Yourself?
Blessed as
I
well.
like the bow tie.
Thank you. Feel free to go away. Feel free to go away. Writing on Mr. Coleman Williams.
Yes, sir.
Good morning, Your Honor.
Good morning, sir. All right, calling case 2355677 of Federation versus Melvin Coleman Williams. Defendant is charged with count 1 assault with dangerous weapon. Count 2 malicious destruction of personal property, $200 or more, or less than $1,000. Count 3 domestic violence.
Good morning, Your Honor. Shelley Grant for the people, P number 60249.
Good morning, Your Honor. Jihad Kadat, P 82492, appearing on behalf of Mr. Melvin Coleman Williams, who stands before this court. Your name for the record?
Melvin Kenneth Coleman Williams Jr.
There's date, time set for your examination. I'm ready to proceed.
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Shalinda Bondi. She was notified of today's hearing. She is not present, and I cannot proceed without her testimony.
Your Honor, the defense moves a motion to dismiss for the lack of complaining witness.
So order, court will dismiss this matter without prejudice.
Yes, Your Honor. May I approach?
Yes, sir.
And Your Honor, I would also like to order Mr. Williams has a tether.
That will suffice.
Thank you. Yeah, wait on. Yeah, he didn't have to.
Are you on Corbin also?
Yes, Your Honor.
Okay. Calling case 2355451 for the state of Michigan versus Dante Wendell Corbin. Finished charged in count 1 assault with a dangerous weapon, count 2 domestic violence. Appearances of the record.
Good morning, Your Honor. Shelley Grant for the people, P number 60249.
Good morning again, Judge. Jihad Kadat, P 82492, appearing on behalf of Deontay Wendell Corbin before the court today. Your name for the record, nice and loud.
Deontay Wendell Corbin. There's date, time set for your examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Christina Oates. She was notified of today's hearing. She is not present, and I cannot proceed without her testimony today.
Your Honor, in light of those facts, the defense moves for a motion to dismiss for lack of complaining witness.
So order, the court will dismiss this matter without prejudice.
Before I leave, would the court allow me to approach for 2 seconds?
Sure.
Let me approach from the right or left, Your Honor.
You're right.
All right. Thank you for your service.
Oh. Got one more.
Yeah.
Okay.
I'm all set.
Okay.
Thank you. Have a blessed weekend.
Thank you, you too.
Yeah, I discussed. records.
Ready on Yolanda Hines. Calling case 2355604, people of the state of Michigan versus Yolanda Denise Hines. Defendant is charged with count one assault, with great bodily harm, arrest, or murder by strangulation. Count two assault with dangerous weapon. Appearances for the record.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Miss Yolanda Hines, who's also present in the courtroom. Ms. Hines, can you please state your name for the record?
Yolanda Hines.
It is the date and time set for preliminary examination. Are you ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Mr. O.C. Anderson. He was notified of today's date and time for the hearing. He is not present. I cannot proceed without his testimony.
Your Honor, the defense will refer to Ms. Phelps this time.
So ordered. The court will dismiss this matter without prejudice.
Yes.
Thank you.
I'll be right back. No, go back.
Dismissal of Marcus Inman.
Judge King. Okay. Officer, can you find out from the strength?
So what?
Hardiman.
Hardiman. Let's see what.
If it's going.
Oh, okay.
Judge King.
Said yes.
Is that what you said?
Said yes. Brown is here. Turn here.
Let's see. Did you find it? All right. Yes. We need to. It's going.
Oh, you ready?
Yes, I am good.
This is case 2355584 for the state of Michigan versus Radasha Mona Brown. Defendant is charged in count 1 assault with a dangerous weapon, count 2 felony firearm, count 3 domestic violence. Appearances for the record.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
Good morning, Your Honor. Sanford Shulman, D43230, appearing on behalf of the witness, Brown, who is standing back to my left.
Tell me your name for the record.
Gradation.
There's the date, time set for the preliminary exam. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Laura Stedman. She was notified today the time to appear. She is not present and I cannot proceed without her testimony today.
Defense is in receipt of the discovery and we're ready to proceed. We respectfully ask the case be dismissed. Advise Ms. Brown is likely to be without prejudice.
So order the court will dismiss this matter without prejudice.
There's some papers.
Because we do have a complaint at the 11:30, and Sandy will be ready to go whenever,
Okay.
There.
Sylvan White, calling case 2355507 for state of Michigan versus Sylvan Xavier White. Defendant is charged with count 1 assault, attempted to rape bodily harm listed murder by strangulation. Count 2 assault, attempted to rape bodily harm listed murder by strangulation. Count 3 aggravated domestic violence.
Good morning, Your Honor. Shelley Gray for the people, P number 60249.
Hey, good morning, Your Honor. Robert Jersey for Sylvan White, P number is 33195.
Tell me your name, sir. Sylvan White. There's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am prepared to proceed at this time. The complaining witness is present. That is in CR1.
And we would waive the preliminary.
Mr. White, please stand up, sir. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have one. You'll be bound over to Wayne County Court as you stand charged. You understand that? You understand the nature and the purpose of a preliminary examination? You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit that was probably caused to be committed. Has anyone forced you to waive your right? Has anyone promised you anything? Are you waiving your right freely and voluntarily? Any objection from the people?
No objection, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily, given the court binds the defendant over to Wayne County Third Circuit Court Criminal Division for criminal proceedings. This arraignment on the information date and time which is March 17, 2023 at 9 o'clock a.m.
Thank you, Your Honor.
That's it.
Mr. Church, they didn't sign the binder.
What time the waiver again, sir?
Here?
Yeah.
Okay.
Okay, I got time to wait. I think that's it right now.
Get a chance, let's get after Mr. Marcus.
Is it?
On the 28th, you signed off on this. Second case, that needed to be signed.
Dismissal Corbin. For that Corbin, they wrote the wrong text on the dismissal.
You just wrote the CTN.
Yeah, they wrote the CTN.
You want to write over it?
Yeah. Right. shots.
Have anybody here on Hardiman?
Yes, sir. Both parties, Ms. Ray said she needs a couple of minutes.
Who did?
Mr. Ray.
Mr. Yu. Everybody else can come in.
Yes, sir.
Good morning, Your Honor. I get disoriented sometimes. Good to see you, sir.
Good to see you, Johnny Eugene Hardiman, calling case 22-55822, for the state of Michigan versus Johnny Eugene Hardiman. Defendant is charged with count 1 assault with a dangerous weapon, count 2 domestic violence. Defendant has a original offender second. Appearances for the record.
Good morning, Your Honor. Shelley here for the people, P number 60249.
Good morning, Your Honor. May it please the Honorable Court, Gerald Eaton, P29182, on behalf of Lieutenant John Hardiman, who stands right behind me.
Tell me your name for the record, sir.
Johnny Hardiman.
Are those sunglasses, Mr. Hardiman? No. Prescription? Okay. There's a date and time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
How many witnesses?
This one.
I would advise the court, Your Honor, I have 2 other witnesses, and I may call either one of you.
Okay.
At this time, the people will call Ms. Ethel Willis.
Good morning, ma'am. Please step forward to your right. Sits the young lady. Give her your name and the spelling of your name. Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat. Share right here. If you would like to place your left, space your right hand. Make it again when you're ready.
I will be asking questions. Please state your name once again for the record. All right. And Ms. Willis, I want to I'm going to be asking you some questions. If you don't understand anything or if you want me to repeat it, please let me know. All right? Okay. And always answer questions with a yes or no. Okay? Thank you. Okay, now I want to bring your attention back to a date of June 13th of 2021. So that's a couple months short of 2 years ago. Do you remember that date? Yes, I do. Okay, and what did you do on that date?
came in over on their block because, well, on Woodmont Street where it occurred, because one of the guys that we grew up with, he passed, so they were having balloons sent off over there.
Okay, so you were going to be sending a balloon send off for someone that was deceased, is that right?
Yeah, for our elementary grade, yes.
Okay, and where was this located?
On Woodmont Street in Grand River.
Okay, and is that in the city of Detroit, the county of Wayne?
Yes.
Okay, and, did you arrive at that area?
Yeah, because my great grandfather's birthday is the, June the 12th. My mother's is June the 12th, and my grandfather's is June 11th. So I really was just being around the community as well.
Okay, all right, very good. So when you got there, were there a lot of people there or just a few people?
A lot of people.
Okay. And was this held inside a residence or a building, or was it outside?
It was outside in front of the house.
Okay. And did you know any of the people that were there?
Yes, I knew the victim that passed. He's been in my class, so I've been knowing him since like the 6th grade.
Okay. So other than the person who passed, was there anyone else that you knew?
Everybody. I went to elementary with all of them over there. That's our school, our elementary. So I knew everybody out there.
Okay. Okay, very good. So while you were there, did anything happen?
Everybody was getting their balloons, and I was parked. So everybody was getting their balloons, and then one of the guys, like two of them, they lived on the same block as my great grandfather before we even started elementary. So when I seen them standing next to Johnny, I walked over there and I spoke and I hugged one of the guys, and we was just as close as the door is. And when I hugged the guy,
okay, let me stop you for a second. You went to hug a guy that you knew, is that right?
Yes.
Okay, did you know the guy's name?
Yes.
What was his name?
Spencer Kitchen.
Okay. And you mentioned Johnny.
Yes.
Okay, where was John?
Standing right next to Spencer, like as close as I am to this glass right here, because everybody was huddling together because the two ladies that was in the lobby, they were in the middle of the street praying.
Okay.
So they were as far behind that fan while we were like about right here from the distance. They were praying to the street and we were standing here and it was 40 more people in front of us.
Okay. Now, you just said two people that are in the lobby.
Yeah, they came.
Okay, are you saying in the out of this courtroom?
Yeah, Tania and Melanie.
Okay, and so you saw the people, those two people here today?
Yes.
Okay, and you said they were there?
Yeah, they were in the street making prayers with their heads down, making a public announcement. And while they were making the announcement before they sent the balloons, I had walked over there and told everybody. So when I give Spencer a hug, when I walk back past Johnny's balloon string,
let me
touch me like this. Okay, that's it.
Okay, all right, let me stop you right there. Because you said Johnny. What is Johnny's last name?
Hardiman.
How do you know Johnny Hardiman?
I met him in my homeroom school at elementary. He was in my science homeroom class.
What grade was that, do you remember?
Like the 8th grade.
Okay, so did you have any other relationship with him other than being in the same homeroom class?
And then we became boyfriend and girlfriend.
Okay, and what grade was that?
We started in the 8th and it stopped in like the 11th.
Okay, so he was your high school boyfriend. Okay, all right. So you said you walked past Johnny and he had a balloon? Is that what you said?
He had a balloon and a water bottle.
Okay.
Because the girls, they gave him a balloon. They were giving out balloons because he had his water bottle. They were giving out balloons, and after everybody got their balloons, they went to the street to start their prayer. So they didn't give me one. They didn't offer me one. So I didn't, it's okay. I was just going to sit to the side like I always do.
Okay. So you give Spencer a hug and then you walk by and what happens next?
Johnny's balloon string touched me like this. And it kind of did. And I said, hey, y'all, don't give it. I said, see this. When I walked away, I thought he was gonna drink the water bottle and he cocked it back and whacked me in the back of the head real hard with it.
Okay, so what happened after that?
When I turned around and seen the bottle that he was drinking that hit me in the back of the head, I picked the bottle up and threw it back over there to them. So when I threw it back over there at Johnny picked up a big old brick that was about this big and he was coming to me like this. And then his friend that he was with grabbed him.
Okay, what happened after that?
That girl, her cousin, her big cousin, and her friend out there, they was like, she gotta go, she better go, cause we'll whoop her A, we gonna whoop her A over here, we gonna whoop her.
Okay, so you heard those statements and then what happened after that?
I went and got in my car and then I went to the police station, cause instead of them asking me how I was doing, I felt when they said they was gonna jump on me, they was leaving messages telling me they was gonna jump on me. So I went on to the police because I didn't do nothing wrong to them people.
Okay, so you made a police report about what happened?
Yeah, because he already bust my head and gave me 7 stitches when I was 17. How many blows he gonna do to me? That's gonna kill me if he keep hitting on me. And I don't even talk to him.
Okay, all right. So I'm gonna back up just a little bit here. So you were hit in the back of the head, you say, with the water bottle.
Like, as I walked away like this.
Okay.
Just like I see your hand in your face, that's how he hit me.
Okay, so did you see him then with the water bottle?
I seen him up, I thought he was gonna scoot the top. I seen him up the bottle and whacked me. I saw that because I was like this. Like I'm looking at her fingers move.
Okay. Okay, and was this just a regular little water bottle?
No, this was a whole liter.
Okay, okay. And so how did that feel when it was hitting you back in the head?
I just now have like headaches, like a sharp, split setting headache because I also have a bone density problem.
Okay.
So I take calcium pills and a vitamin D and a calcium citrate. And I was born with this disease.
Okay. So this happened, you went and made a police report, did anything else happen on that?
No, I left. I came back over there because I thought that I could tell them, the family, that I made a police report because he had no business hitting me. But they are sent me a telegram saying they gonna jump on me, the guy who died, his baby mama, her friends, his girlfriend, all of them gonna jump on me every go round. That's what it always be with them and me. They gonna try to jump on me. They gonna tell me, they gonna make it understood that they wanna fight.
Okay, so you did go back over there?
I parked a couple of blocks, like a couple of houses down, but I had told them that I got the police in it.
Okay, okay. So again, to back up just a little bit, after you threw the bottle back, you said that Johnny picked up a rock?
A brick, a big, you know those little bricks that shape like this?
Okay.
That you can put on the flower bed and make one of them bricks.
Okay. Okay, and had you seen that before? Like, were those around?
They got them around their house, that's what we was at, it's a lot of them.
Okay. And you said he held it up?
Yeah.
Okay, did he say anything to you?
He was coming for me with that brick and his friend had to hold him.
Okay. And how far away was he from you when he was coming toward you?
I would have been from where I'm at to the other, and he was probably before that podium.
Before this podium here?
Yeah, that's the difference we are now from that.
So maybe 10 feet?
10 to 12 feet.
10 to 12 feet. Okay. And then you left after that.
Yeah, because everybody was saying, no, I'm okay, but get her come over here, but we beat this beating.
Okay, thank you. I have no further questions at this time. Stay right there.
Cross-examine.
Thank you, Chair. Ms. Willis, I have some questions for you. If I ask you something you don't understand, don't try to answer it. Just tell me to rephrase it and I'll rephrase it, okay? You have to
Yes.
out loud. Okay, and the individual, this was a memorial service for someone who was deceased, is that right?
Yes.
And what was the name of the person who was deceased?
Andre John Mills.
The name was Andre John.
Mills.
Was it John Andre Mills?
Oh, yeah, could be that.
Could be John. And when did you last see John Andre Mills?
Probably about a month before that.
And where had you seen him?
On that block.
And I believe you indicated that, were you invited to this ceremony?
I was invited at the ceremony from their cousin Felipe Nicola Martin, the one who made a police report when I had to come to court prior to this.
Felipe Martin, you said?
Yes.
And who is Felipe Martin?
John Mills' cousin.
And you made a police report in connection with him, you're saying?
No, I had an incident report with him. In, I think it was 2016.
You made an incident report against him?
We started dating and we got into it. And we had got into it.
I don't want to belabor this. You made a police report against him in 2016?
Yeah.
At the Detroit Police Department?
He made one against me.
Well, he made one against you?
Yes.
Okay. Now, I believe you indicated that when this incident occurred, and by the way, you made a police report and you were interviewed by the police, is that right?
Yes.
And you made a statement, is that correct?
Yeah.
And you signed the statement, is that right?
Yes.
And there's nothing in the statement about Johnny Hardiman picking up a brick or throwing a brick at you or threatening you with a brick, isn't that correct?
Okay.
Please answer my question, ma'am. Do you need to see your statement?
No, I don't need to see no statement. It's
Okay,
easier for me to talk than to write. That's all. I have a bone density problem. I can't write. My fingers, yeah, I'm listening.
But I'm saying your statement says nothing about him picking up a brick and threatening you with a brick. You do know that, isn't that right?
Yeah, I do.
Okay.
I do.
All right, and you just left that out when you were talking to the police, is that correct?
I didn't talk to them. They didn't want to talk to me. It's just like I'm trying to tell you the story. It's kind of hard for me to write a whole story when if I can tell you, it's easier to tell you the whole layout than for me to write the whole story in 5 minutes.
But when you went to talk to the police, they asked you questions.
They didn't really ask me no questions. They was pushing this in the door, out the door. They didn't really give me as much time as I'm sitting with you now.
May I approach the witness room? You may. Ma'am, I'm gonna show you.
I know what I wrote it hysterical after somebody cracked me in the back of my head.
I'm gonna show you what I shown the assistant prosecutor, which I believe is a 2-page copy of your statement. You look at that, ma'am?
Okay, I can read it. They asked me to write down as little as I could. No, that ain't what I wrote. I don't remember writing on that page. I know my handwriting. I wrote that. I'm an essay writer. I've got scholarships for that in elementary, but I didn't see this one.
Wasn't this statement written by a police officer?
No, my handwriting is up under it. That's my handwriting. That's not mine. Excuse me, can you turn? I wrote this paragraph because that's all they told me to make a paragraph and keep it as brief as I could. Yeah, that's my signature, but that wasn't up under it, all of that paragraph that's up under it. That wasn't up under it when I wrote mine. This wasn't. I wrote this wasn't filled in.
These questions were written by police officers, right?
When I got the paper was blank. I only wrote this much. My name and stuff should have been on here. I only wrote this part. So this looked like this was cut and copied because none of that was even on that document. All of that extra writing on there, that just popped up. Only thing was on that document was my little essay and my signature, and probably they were gonna fill out the top. That's it.
So for the record, we're talking about page 1 of your statement. You're saying that this little paragraph that has answer by it, I was standing on the front of the lawn at 14754 with my, you said that's all that was on the page.
Okay, that was next door. They told me to write down, here's the house where it happened. I was standing next door. I wasn't even on their property.
just asking about what you said you wrote.
Yes.
You're saying the question, what happened on June 13, 2021, around 9:30 p.m. at 14-161-60 Woodmine? That question wasn't on the tape.
Not at all.
So the questions weren't there, just your answer.
Yeah, they didn't give me no paper with no question on it that they handwritten.
But you do
They
it-
gave me a blank paper and said, "Can you write down what happened and keep it as brief as you possibly can?" And then now all the other stuff is filled in on that, which makes me say, it looks like it was cut, pasted, and copied, and Xerox, and printed, as if all of that was on there, then my summary came.
Okay, you said you indicated you saw Tania Mills outside in the hallway today at 4, is that right?
Yes.
And you saw Melanie Terms, is that correct?
Yes.
And Tania Mills is the sister of the deceased, John Andre Mills, is that correct?
Yes.
And her family, they were actually having this memorial service, is that right?
Yes.
And before you say Mr. Hardiman was violated you, you said that you were touched by the string of the balloon he had, is that right?
Yes.
Isn't what happened that you tried to snatch the balloons out of his hand because nobody gave you a balloon?
I don't wanna snatch no balloon from nobody. It touches me around the time when my mother's birthday is coming, because my mother is deceased, and my sister skipped school with a guy, and my mother fell out and died in that house. I don't wanna snatch nothing from nobody, not no balloon.
So your answer to my question that
No, I didn't touch his balloon. The string touched me, and then when I said, "See y'all," as I walked away, he whacked me in the back of my head.
And that was when you're saying you brushed up against the string and that's how it touched you?
The wind blew the string from him to everybody, the wind blew the string and it touched me. And after he hit me and after everybody knew that I had went and got the police, 3 days later, they come up with, I snatched his balloon. I wasn't gonna snatch no balloon during no trying time like that. I wouldn't have done that to nobody.
And if somebody said that happened, they're just not telling the truth, is that right?
I didn't snatch that, nobody's balloon, one balloon or two balloons. What I'm supposed to do with it, I know how the people talk to me. I'm already going through something with their blood cousin because I don't want to be bothered. You want to mess with Johnny, you want to mess with Johnny. Next thing I know, I'm in jail for doing something to him that I never even did. So they all got a little thing going where they keep falsifying and making up police reports. And like I told them, I worked for the Jewish Federation for 13 years. Committing perjury is gonna get you locked up. It's gonna get y'all in trouble for falsifying police reports.
Ma'am, have you been the subject of proceedings in probate court between 1983 all the way up to 2013?
I probably have.
Where people had to actually have you placed in a hospital facility because of mental problems, is that right?
No, because Johnny left a condom inside of my cervix and caused me to have an ectopic tubal ligation. And I didn't have to get a hysterectomy because technology had changed. So they were able to unravel the condom and get it out of my fallopian tube, which now makes me high risk.
But you have been the subject of probate proceedings from 1983 all the way up to 2013, isn't that correct?
Not for that. I went because
for whatever reason.
For the condom that was left in my cervix.
And what year was that?
Not no 83. You know how old I was in 83.
How old are you now?
83 years old. You think I was going to probate court, going to jail for that?
No, I asked you how old are you?
I'm 50 years old. I'm half of 100.
Okay, and you were the subject of a probate court petition in June of 2013, is that correct?
Yeah,
in front of Judge Judy Hartsfield in probate court, is that right?
Okay.
Is that correct? Yes.
I don't know what court it is, so I'm just saying, okay. I don't want to say yeah, when I don't know exactly. You know how many times I go to court? You know how many times I've been framed? You know how many times I get a whooping if I get in trouble and I don't do nothing, I'm not gonna do nothing
when you
wrong.
When you were struck by this water bottle, did you go to the hospital or did they doctor get any treatment?
I went to the police station. Stop hitting me. If you just stop hitting me, stop hitting me. He already hit me in my head with a Lysol can and gave me a bunch of stitches in my head when I was only 17 because I said, the doctor said that my cervix is not healed yet and I can't have sex. And I'm sitting at the table doing homework. When I look down, doing my homework, he busted my head 3 months after my mother died. So I'm trying to get back to school, do my homework. He busted my head, blood everywhere, because I said I didn't want to have. So I don't touch and mess with him in real life.
Okay, now my question was, the day you say he put the water bottle and hit you in the head, did you go to the doctor and have yourself checked out about that?
No.
Did you go to the hospital for any treatment?
No, I went to my own doctors. I didn't go to the emergency room. And I told my doctors, I have doctors who take it very serious when people hit me because of my bone density.
When did you go to the doctor after you say you were hit by the water bottle?
I go to the doctor faithfully.
I mean, how many days after how many days after you were hit with the water bottle did you go to the doctor about being hit with it?
Probably about 5 days, maybe.
And where's that doctor's office?
It's probably my primary care doctor more than likely. My primary care.
Is that probably where you went?
That's more than likely 9 times out of 10, but I also have a scoliosis specialist who knows about it as well. So that's another doctor. But I'm sure they know. They all know about it because I told them. Because I don't have a mother to tell that to. So I definitely told it to my physicians.
Okay, I'm nothing further to.
Can you reiterate? Thank you, man. You may step down. Please bring it back to the next one. Thank you.
I have
Any other witnesses for the people?
I'm sorry.
Any witnesses for the defense?
Yeah, I have a couple of very short things.
Ma'am, please give your name and the spelling of your name to the young lady seated there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, and what you have? Yes. Thank you. Please have a seat right here. I have you take this microphone, distance in your left, speak everything. I'm ready to begin when you're ready to speak.
Thank you. Ma'am, would you state your name for the record?
My name is Tania Mills.
And during his life, were you related to John Andre Mills? Johnny Andre Mills?
Yes.
And is he deceased?
Yes.
And when did he die?
Um,
Was it 2021?
yes, June 2020.
And was there a memorial service held prior to his funeral?
Yes.
And do you know Johnny Hardiman?
Yes.
And did Johnny Hardiman know, I'm sorry, and how are you related to John? Were you related to John?
Yes, he's my brother.
Okay, and could you point to Johnny Hardiman in the courtroom? Did you see him?
I'm here.
Record, identity, insurance.
So no.
And did Johnny Hardiman know your brother?
Yes.
And were they close?
Yes.
Was he your brother's best friend?
Yes.
And at his memorial service, do you recall Mr. Hardiman being present?
Yes.
And do you recall any incident occurring?
Yes.
Do you know Mecca Wills?
I do.
Was she invited to the service?
No.
But why not, if she wasn't?
Mecca has a history of kind of not that severe. She she's not really very severe. She starts to look at She's just not throwing it out and like, so my brother, don't worry about it.
Let me ask you another question. Did you see her on that day?
Yes,
Was there any incident you observed on that day?
yes.
What did you see happen?
I saw her, we were actually in the middle of training. And I saw her run up to Johnny, meet him, and snatch the balloons from him.
She kneed him. When you say knee him, what do you mean?
So I took her knee and meet him, trying to hit strike.
She struck him with her knee in his lung area.
Maybe like, she didn't get it, maybe like a leg.
And what happened then? What was Mr. Hardiman doing at that point?
I think he was kind of caught off guard. She snatched the balloon and she ran, maybe like 2 or 3 houses down. My best friend was praying and she stopped because mental brain kind of anger out of you and like I said, it was my brother's memorial. So I kind of got upset and I was maybe ready to fight her actually.
Let me stop you there. When you saw her knee Mr. Hardiman, did Mr. Hardiman have any balloons in his knee?
Yes.
How many?
Maybe 3 or 4.
And did he strike her at all?
No.
Did he have a brick in his hand?
No.
Did he ever pick up a brick?
No, absolutely.
Did you ever see anybody with a brick that day?
No.
Did he hit her in the head with a bottle?
No, she moved too fast. She got away from
I think it was kind of disruptive to the world. So your brother had died, what, 2 days before?
Yeah.
And this was before the funeral?
Yes.
Did anybody do anything to her after this incident occurred? Anybody attack her?
No, that's all.
Where did she go after she snatched the balloons?
She ran maybe about 2 houses down. My best friend was talking to her like, would you just please leave? We didn't invite you here. You have no reason to even be here to serve and what's going on. She busted the balloon.
Which balloon did she burst?
The ones that she snatched from Johnny.
And I guess you heard the noise. Did she pop them? Is that what you're saying?
Yes.
And your best friend, is that Melanie Hearn?
Yes.
Is she the person that was singing the prayer?
Yes.
I'm looking for this.
And how long have you known Dr. Willis?
She went to school with my brothers. I've known her for a long time. That's how much I know that.
Okay, and before this day, in June 2021, when was the last time you received her hearing?
I see her a lot. She comes around a lot. She'll sit in her car. We don't talk to her or anything. She don't start anything, but she'll just sit in her car across the street from my house. So maybe I'll see her before my brother passed. I tried to see her. About 2 weeks or something. It was the summer, so we always outside. So she'll just go back to the shop.
Okay, so, when you say that you saw Ms. Willis, approaching your brother, I'm sorry. Sorry, approaching Johnny. How far away were you?
Johnny was actually standing in my driveway. I was actually standing at the bottom of the driveway. It's a long drive. He was standing up there with my other brothers and some of our friends.
Okay, and how many people do you think were there in that area?
In that area, maybe about 15.
15, okay. So you said that you saw her.
She walked right past me.
She walked right past you?
I was at the bottom, I was on the driveway, she was walking on the sidewalk.
Did he have a water bottle at that time?
He had a regular water bottle.
Okay. And did you see anything happen with that water bottle?
No.
Did he keep it in his hand the whole time?
I think, yes, he did.
Okay.
Yeah.
So after you saw Ms. Willis take the balloons, you said she ran away?
Yes.
Okay. And what did Johnny do eventually? He was kind of shocked, but not surprised. Like, he just stood his head, basically. He didn't move. He didn't go anywhere there.
He didn't do anything. Did anybody else do anything
No.
after she?
Like I said, my best friend, we know her, but my best friend kind of stepped in quickly and was talking, like, go ahead, leave, you know, we didn't ask you to come. You wasn't supposed to be here. She actually went and sat in her car and still didn't leave.
All right, I have no further questions.
Can you redirect?
No, Your Honor, I'm not gonna ask. Oh, I have no further questions.
All right, thank you, Mr. Any other witnesses?
I'm not gonna call it.
People?
Your Honor, I.
Oh, you know what? Can you come back for a moment? Ma'am, can you come back for a minute? Ma'am. I'm sorry, I did have a couple of questions for you. We remind you, you're still under oath, okay? Come back up. Yeah, come back up. So when this incident happened, you indicated that you and your friend were praying in the street, right?
Yeah.
When you were praying, did you have your head down, eyes closed?
No, I didn't.
Didn't have your head
I was
down,
looking
eyes
around.
closed?
I was actually video recording.
So you said that your friend talked to complaining witness, Ms. Willis, after she beat the defendant. And you said when she beat the defendant, she grabbed the balloons and took off running, right? How was she able to talk to him when she took off running? She ran so fast, like
She ran like to that house. She ran, like my house is right here. She was just driving. She came down the driveway and she went like right here. And then my friend stepped, we both were standing right there. She stepped up the driveway and she was yelling something. I don't remember where she was yelling. And my friend was like, just go, like, we didn't watch you. Like, why are you even here?
You were watching her the whole time?
I watched her the whole time.
Why? I
Because
thought
I
you
always
were
like,
filming everybody.
she's very vindictive, and I was watching her. I didn't want her to be it.
But I thought you were filming this.
I mean, after that, I seen what she was doing. She came to my brother's funeral and cried.
Sorry?
She came to my brother's funeral and cried. She knows.
Disguised.
Yeah. She had a funeral on, she had a funny line like this. She wanted one.
Any questions based on my question?
It's just brief. Do you know if she had a vehicle there that day?
Yes.
Her, and that was an automobile. Where was the automobile parked?
The automobile was parked, maybe, actually, about 4 houses down.
Did she ever go to that car?
She did.
How long after this incident with the balloons was that she was there?
Right after my friend was talking to her, like, could you just leave? Could you just leave? She was yelling stuff, but she was still walking away.
So after Miss Harris talked, and Herman's talked to her, she went and got in the car.
Yeah.
How long did she stay in the vehicle?
The rest of the day, she didn't leave, she just stayed in the vehicle.
You didn't see her drive away?
No.
She was there for how long?
Until we were,
How long were you there?
we were there probably from, maybe 5 in the afternoon to about 10 that night.
Okay, thank you. I'm not.
Anything else, Ms. Karen? All right, thank you, man. You can step down. Ms. Strange?
Thank you. Judge, I'm going to ask for a final word charge. We are here for a preliminary exam, and this court has the task of determining the credibility of the witnesses as the testimony that is presented to establish probable cause for these charges. So the complainant testifies, and I would say that my main argument here is that she testified over and over that that the defendant hit her in the back of the head with a large water bottle. She did talk about a lot of other things that had happened in the past and things that were going on right then, but her testimony was very clear. She didn't, if this didn't happen at all, why did she say that this happened? She said she was there. She said that the part of the balloon had touched her, but she was walking away, and then she could see out of the corner, she could see out of her eye because she said several times she went back to say hi to everybody. And that's when she saw the defendant hit her in the back of the head with the water bottle. She even says then she picked it up and threw it at him. And that's when she then says again, he picked up something else, but she didn't mention that before, that isn't charged as that today. But she was very clear about what happened with the water bottle, from the day that it happened, up to today. So I do believe that, she was a credible witness based on what happened that day and what he was charged. So I'm asking for a mind today.
I would just state the following, in deference to my esteemed colleague, who I have great respect for, she does an outstanding job for Kenneth as a woman prosecutor. The complainant's testimony was anything but clear. The court can come to any number of conclusions, I guess, based on the right candidate, but I think it was anything but clear, and I think it should have been clear if she later described an event that in many ways was more threatening than what she alleged. She says, my client hit her with a water bottle. The court knows that the law of felonious assault requires that a person be assaulted and or battered with an object that could cause serious injury. I suppose a plastic water bottle under some circumstances might do that. I don't think it was described in a way here that would be sufficient to make that a dangerous weapon within the meaning of the statute. So that's one argument that I have. But more to the point, I think for People versus King and People versus Joseph, the court knows that it has to assess the credibility of all witnesses. It has to, quote, as the statute says, examine the entire matter. Obviously, you can't make credibility calls that would be the type that we made at a trial. You know, we have conflicting testimony. But I think that obviously there are situations where a witness's testimony is inherently credible. Admittedly, I did not mark and admit her probate file. She acknowledged that she had the probate history from 83 going up to 2013, which she didn't compute it, and that she was the subject of probate orders. I think that kind of explains her behavior, and the fact that she has, by her own description, this sense that people are after her, everybody's coming after her, and that she has to defend herself because of those things. That she would leave out of her statement something that's important, is the defendant picked up a brick on the same day and was going to threaten her with a brick and had to be restrained. And then when confronted with that, she acknowledges it's not there, but then she says, well, the police made everything up on the paper. Right? I wrote one thing, the sheet was blank, and now the stuff you're showing me, the questions by the police officers that were written by them, your other answers were all things that they made up. That, I think, speaks to kind of paranoia that is consistent, and I use that in a colloquial term, and that is consistent with her affect and demeanor in this case, along with her assertions that my client attacked her for no reason in the mid-level memorial service, where he was moralizing his best friend. After her saying she did something that would cause him to do that, her description was that she touched up against the string and walked away, and that in response to that, the defendant interrupts the prayer for his best friend, and then proceeds to attack her. That makes no logical sense. And I think on this record, Your Honor, her testimony is inherently incredible, and I would ask the court to dismiss it.
Anything else, Ms. Dre?
Nothing for the judge.
Okay, so I'm presented with a witness, Ms. Meg Willis, who in this court's purview appears to be someone who has experienced a fair amount of trauma in her life. What that trauma is, I don't really know. That's how she presented herself. I found some portions of their testimony, and I say some portions of their testimony, we inherently credible. I don't believe that the string to a balloon just caught onto her and she was bashing the head with the bottle as a result thereof. I think there's a little more to the story. She tried to distance herself from her responsibility and her role in it. I think that she did snatch the balloon because she probably had some problem with not being given the balloon. So she snatched the balloon on her own. I also believe that I don't believe that the defendant didn't do anything as a result of the balloon being snatched. This is a rather emotional event. He just lost his best friend. He's standing there with the balloon. How dare she snatch the balloon from me and run? And I believe that he just stood there and shook his head and was like, I kind of expect that because I know how she is. No, I don't believe that happened either. So the defense witness that was called, I don't entirely believe her story either. In that she's praying in the street, that she's praying with her eyes open because she's videoing everyone, but yet she sees what's going on behind her. I don't believe that. I believe that the complainant, when she says that the defendant did hit her in the head with the water bottle, I do believe that happened. Not so sure about this alleged break, but that's not the basis of any of the charges here. But I believe that he did react to it. I don't believe she snatched the balloon, took off running, and he just stood there. That just defies logic as far as I'm concerned. I think that him being upset of the event in which she did, that he reacted by hitting her with this water bottle. I'm not so sure. I don't know if I believe whether or not the complaining witness need the defendant in the groin area. She may or may not have, I don't know. But I do believe that she tried to snatch the balloons and run, and the defendant acted as such. So that only leaves the remaining question as to whether this water bottle can be considered a dangerous weapon. Was it used in a fashion to be a dangerous weapon? And I submit that it could be considered a dangerous weapon, given that it was a plastic bottle. And although the dimensions of the bottle weren't flushed out in this example, nor was there a description of this bottle. But the general sense of a water bottle is a hard plastic bottle of some sort that is designed to contain liquid. Yet to run across a water bottle that squeeze very soft in nature. But I believe it's a question of fact to be determined by a trial or after hearing the testimony of witnesses involved in this matter. It's satisfied that people admit their burden of probable cause as it relates to the charges of taking the complaint. Court finds the charge was committed in the city of Detroit. Court finds probable cause to believe this defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time of March 24th, 2023 at 9:00 a.m. And again, I'd like to reiterate that as it relates to the witness, this court is free to believe all, part, or none of the witness's testimony. This court believes some of it and don't believe other portions of it. Portions of it that I do believe amounts to a felonious assault and domestic violence. The defendant's arraignment began on the information of March 24th, 2023 at 9:00 a.m. Thank you.
Did you say the AOI was 324?
Yes, sir. We have parties here for Dudley Dalton. Let's go on here, Mr. Arnold. Good, sir. How are you? Good. Are you ready on Dalton?
Yes, Judge, that's done.
You have witnesses, Mr. Green?
No, Judge.
Take care, Judge. Good seeing you.
All right, take care, Mr. Lee. Good to see you. Enjoy the weekend. Dudley, Leverson, Dalton, calling case 2355583, people of the state of Michigan versus Dudley, Leverson, Dalton. Finish charged with count 1, assault with dangerous weapon, count 2, felony firearm, count 3, domestic violence.
Good afternoon, Your Honor. Shelley Green, with the people, P number 60249.
Good afternoon, Daniel R. for Mr. Dalton, P 61807.
Tell me your name, sir.
Dalton.
Designate time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Anaya Abdul Rahim. She was notified of today's hearing. She is not present, and I cannot proceed without her.
That being the case, I move for dismissal.
So ordered. The court will dismiss this matter without prejudice. Move dismissal order, Mr. Arnold. Michael Clay. Calling case 2355602, people of the state of Michigan versus Michael Clay. Defendant's charged in count 1, domestic violence, third offense. Defendant has an habitual for the fourth offense. Appearances for the record.
Good afternoon, Your Honor. Shelley Green, for the people, P number 60249.
George Burke, shows P 38805, that's the Cape telephone.
Good morning, Your Honor. Adam Willett, P number 55741. Judge, I was court appointed to the case. I didn't know he had retained counsel. I asked the court to excuse me.
So ordered. Thank you. Have a good weekend. There's a date time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Marilyn Braxton. She is not present, and I cannot proceed without her testimony today.
Under the circumstances, for dismissal without prejudice.
So ordered. Court will dismiss this matter without prejudice. I need a dismissal order. Okay, that being said, folks, we're down for lunch to 1:45. unless Ms. Drain knows something I don't know. About our 1:30.
I do not think that first day, we weren't even able to get something. So, I mean, that's all I have to say about that. You never know, I lose sometimes.
Right.
Judge, may I ask a question?
Yes, sir.
The client's got a tether, GPS tether.
Dismissal order to take care of it.
Okay. Do you need to contact the tether agent, I'm assuming, or that's done?
Just show them the dismissal order.
Want to wait here or?
Right.
Hey, Jeff, I'm gonna make a suggestion. All right, I made a suggestion.
Sure.
We leave this microphone here so people don't break it. If we do this, if we break it, kick it in.
Okay. This is just that it doesn't go all the way down. You know,
Well, it's better than having no microphone, but it's not great.
Okay.
Whatever you can do. So this, I know. This is why you're here, so. Oh. Oh, yeah, some code.
Great, if I can use this number.
Don't you want something?
Yes.
No.
We have been unable to. Yeah, so, you know, I mean, I just, you never know, sometimes people end up looking up something on, you know, so you're finding it. So, I mean, I can't say 100%, I'm just saying no one in our office has been in contact. Okay. 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 Okay, very good, thank you. Okay, bye.
Yes,
I like you put your mask on.
because she was making me laugh.
I was trying to not make my eyes squint up because I was like moving around like, just calm down, because I was too.
I think you did get a little.
Oh, yeah. But-
She's way out.
You know, they don't want her around. They don't want her coming around. So- Oh, my goodness.
She snatched that anyway.
Oh, my goodness. Yeah, Arnita came and rescued me. She's still talking.
Huh?
She's still talking in the witness room.
Oh, really?
She's still talking.
I'll be talking when you get back.
I know. So I gotta say, like, thank you.
She
you
has
know.
some mental health issues.
I know, yeah, she does. Oh, boy. This is why I knew, like, this is gonna be a real one. All right.
How bad is it out there?
It looked like it was bad. I mean, they put salt down, so it smelled.
Those are white.
like today, I did with the, you know, the one in the case got Kenneth with. So, and then they disappeared. To like maybe take one of those, fill it out, and then email it to you, or no?
Yeah. Email it to me. And can you, if you know, like a day ahead, where I can put it on the docket, pull the file.
Okay.
Yeah, cause stuff gets lost and I don't have my files.
Okay.
Yeah.
Okay, that's what I'll.
Yep, let me know. And whatever, so I can pull the file, at least pull the file.
Okay. Because, yeah, so I actually. He said, okay, we'll probably do here tomorrow morning, which was yesterday. And then I saw him, he's like, oh, we're gonna have for sure here tomorrow.
Okay.
So
what I'll do is, at least I'll be able to pull the file, have it on my desk.
yeah, okay, so that's what I'm gonna do.
Yeah.
So next time I do something like that, I'll let you know. So, because if I can move, they're not gonna- I don't know why we have to wait for the day and time.
Right.
Everybody,
Right.
it's easier.
Okay.
So. Okay, so I'm gonna do that. So
Okay.
next time, if we do that over Zoom, I will fill out the dismissal and then I will email you.
Yeah, and that'll work out perfect.
Okay, thank you. There's some water in here.
There's no water?
No, there is, I just didn't see it,
Oh.
because it's behind here, so if you're over here, you can't see it.
Oh, okay.
Hey, can we get Scott upstairs?
What's happening? Hey. All right, this is Mr. Scott. Use copy to say, okay. I know. Okay. Nice to see you. Nice to see you. To camera.
don't have to say it. I did think that, defense counsel was going to appear by Zoom. Why here?
Okay, here he is. Mr. Harris, are you there? Mr. Harris. Good
Yes.
afternoon.
Good afternoon.
Calling case 2157411, people of the state of Michigan versus Catone James Anthony Scott. Defendant is charged with count 1 home invasion, first degree, count 2 domestic violence, third offense notice. Defendant has a habitual offender, fourth offense notice. Appearances for the record, please.
Good afternoon, Your Honor. Shelley Drain for the people, P number 60249.
Good afternoon, Your Honor. Wyatt Harris, P54891, on behalf of Mr. Tone Scott. I appear via Zoom with the court's permission. I believe Mr. Scott is in person.
Mr. Scott, tell us your name for the record, sir.
Tone James Anthony Scott.
All right. Today is the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is the Ms. Gabrielle Mullen. She is not present today, and I cannot proceed without her testimony.
Mr. Harris?
We move for dismissal, Your Honor, of this case.
So ordered, the court will dismiss this matter without prejudice.
Thank you, Your Honor.
Have a good weekend.
You too. Be safe.
Thank you, you as well. Okay, that concludes the docket for today. You guys have a great weekend. Stay safe, please.
Thank you.